Hi, everyone. I'm going to continue with the legal terms for this lecture. And the first one is liability, which is the legal responsibility that a nurse practitioner has for actions that fail to meet the standard of care, resulting in actual or potential harm to a patient. So the standards of care are used as criteria to measure whether any type of negligence has occurred. Standards of care come from federal laws, state laws, Board of Nursing. That's how standards of care is measured. And this is how this is measured. The standards of care, that's how standards of care are come up with. And then that's how we measure if there's any negligence that occurs. So let's talk about negligence versus malpractice. So negligence is the failure of an individual to do what a reasonable person would do, resulting in injury of the patient. So, for example, negligence examples are misdiagnosing a patient, failing to diagnose a patient, delaying a diagnosis for a patient, botched anesthesia, botched surgery, the wrong leg amputated, something like that. That's negligence. Now, malpractice, failure of a professional to render services with the degree of care, diligence, and precaution that another member of the same profession under similar circumstances would render to prevent injury to that person or to that patient. So something reasonable that should have been done to prevent injury. And it may involve professional misconduct, just what it says, an unreasonable lack of skill, doing something that you really never should have been doing in the first place, illegal, immoral conduct, anything that's illegal or immoral, other allegations resulting in harm to a patient, okay? Harm to a patient right here. So when we talk, so malpractice insurance does not cover an APN from charges of practicing medicine without a license if the APN is practicing outside the legal scope of practice for that state. So this is something that malpractice insurance does not cover. So you have to make sure that you are practicing with a license and you're properly certified to be covered by malpractice insurance. So medical negligence is a provider's actions or inactions which fail to meet the medical standards of care. Malpractice is if the medical negligence causes a patient to suffer any type of injury or harm. Okay? Next, assault and battery. Assault is an intentional act by one person that creates an apprehension in another of an imminent harmful or offensive contact. An assault is carried out by a threat of bodily harm coupled with the apparent present ability to cause harm. For example, shaking a fist in the air in the direction of another person, making a motion to inject someone against his will, to cause somebody to fear imminent harm. Basically, assault is threatening them. So it could be just shaking a fist in their direction, making some kind of a motion to threaten somebody. Where battery is an illegal, willful, angry, violent, or neglect striking, okay? Actual striking of a person, or striking of his clothes, so just kind of like pulling on clothes, or anything which he is in contact with, his hair, pushing, hitting, kicking, anything like that. One can commit battery on an unconscious person, but they cannot assault an unconscious person, right? Because the person doesn't recognize that they're being assaulted, so know the difference between the two. Yeah, so battery actually refers to the actual act of physically harming someone. So defamation, a communication that causes someone to suffer damage or reputation. Two different types. Libel, which is defaming, distributing written material, posting a disparaging comment, writing a false claim about somebody, and acting as though it's the truth. So-and-so killed somebody when they really didn't. Slander is spoken defamation, so the same thing, but it's spoken to somebody other than the person. So it's spoken to another person about somebody. So as far as somebody being able to, so the libel is written material and slander is spoken defamation, but they're both examples of defamation. And in order to have a defamation case, they have to prove that somebody's reputation was damaged. Involuntary commitment. In most states, there's a duty to commit someone who's in danger of hurting himself or others as a result of mental illness. For example, a patient who is attempting suicide, basically not commit suicide. That's a misprint there. I shouldn't have put that in there. So a patient who attempts suicide would be an example of that. A nurse practitioner is potentially liable if a patient's discharged while they are in danger of hurting himself or others. Discharged by the nurse practitioner, not necessarily somebody who walks out on their own. Next, the use of restraints. It's legal to forcefully restrain someone to prevent a patient from harming themselves or others. The nurse practitioner must document the exact reason or rationale why the restraints are being ordered. Okay. A nurse practitioner may be liable if excessive restraints are employed on someone, so more than they need. The exact reason for the restraint is not documented, or safety checks of the restraints are not charted. That's important to know. This is always on certification as far as when are restraints legal. The Good Samaritan statutes protect healthcare providers from lawsuits who aid at the scene of an accident and render reasonable emergency care within the nurse practitioner's scope of practice, even if the outcome is poor. Even if you stop at the side of a road and you perform CPR on a patient and the patient dies, and that was a reasonable emergency care within your practice, that's completely, you're completely protected with that. You're not going to be tried for murder. Okay, just some other kind of concepts here, or just like important information. Dismissing or discharging a patient or closing a practice. A nurse practitioner cannot withdraw from caring for a patient without notification. Here's some examples of reasons for discharging a patient for practice, including abuse from a patient, refusal of a patient to pay for their services, and number 3, patient's persistence non-adherence to recommended care. So somebody who is a prescription abuser, somebody who never pays their bill, somebody who never shows up, maybe a patient who swears at you, somebody who's stubborn and they self-diagnose themselves. When these patients show up at your practice, they can really grate on your nerves and bring the worst out in you and ruin your day. So what do you do about these people? So I've experienced this, and patient dismissal is really a drastic step that most providers hate to do. Not only will failing to discharge a patient cause you stress, it could endanger the patient as well. It could also cause some serious legal issues for the provider down the road. So just kind of something that I've learned along the way and been told malpractice attorneys report that they can hardly think of a time where a malpractice case went to trial and the nurse practitioner or the physician did not say to them, I knew that patient was bad news. I just hoped that that person would go away. I should have taken the time to dismiss or terminate that patient. It's generally people who should have been terminated that keeps the provider up at night. So this is reasonable. These are reasonable reasons to discharge patients. And I haven't experienced an abuse from a patient, but I definitely have had to discharge a patient because they've just been non-adherents and they just wouldn't adhere to recommended care and they were continuing coming back. And sometimes it has to be done. So steps for discharging a patient: send a certified letter with a return receipt requested and get a copy for the chart. The content of the letter should be general versus specific. There doesn't need to be specific details, and I'll show you an example of one. Provide general health care coverage for the first 15 to 30 days post-termination deadline for this person, so they're just not out on their own in case something happens to them. Obtain release of information to provide copies of all needed records for the subsequent care provider that they're going to go to. So physicians or nurse practitioners can end a patient relationship for many reasons, including the ones that we spoke about. They also can discharge patients for being uncooperative. Like we said, they don't follow medical advice, they don't keep appointments, they don't pay their bills, they're disruptive, sometimes they're unpleasant to the staffs. In virtually any non-discriminatory reason, providing that the patient is given proper notice and they don't withdraw from caring for a patient who's in the midst of a medical crisis. So the decision to end this relationship should be made by the nurse practitioner or by the physician, never by the office staff. Okay, they don't have the ability to terminate a relationship between the provider and the patient. Here's an example of a letter that should be sent by certified mail on date with return receipt requested. I find it necessary to inform you that I will no longer be able to serve as your physician/nurse practitioner. The reason for this decision is a general statement. As you may require medical attention in the future, I recommend you promptly find another physician provider to care for you. You require ongoing medical attention for the following, and the diagnoses can be listed there. Contact the local medical society for the names of providers who are accepting new patients. I will be available to treat you on an emergency basis, and then insert a date here. Within 15 to 30 days is in a reasonable time frame, and will give you time to find a new provider. Enclosed is an authorization form that permits me to send your new physician a copy of all their medical records, and this is a totally suitable general letter that gets sent to the patient. Obligations in closing a practice due to relocation, retirement, or maybe just whatever changes and you want to close your practice. Give the patient adequate time to find another provider. Keep all files for a minimum of 5 years. Follow state laws regarding any storage requirements. So we have to keep their files if you have actually hard copy files. To avoid complaints of patient abandonment, provide timely notification, the names of other providers and resources so this patient can have some future care. Okay, so some mistakes. Number one, abandoning a patient. So once a provider has established a patient-provider relationship, the provider cannot abandon the patient. Abandonment is a problem when the provider terminates a relationship with an individual patient That can also be a problem when the provider closes their practice. And that, in essence, is going to terminate all relationships with all the patients. If a provider abruptly closes a medical practice without prior notice to a patient, that is considered abandonment, or fails to notify someone as far as their like a population, like maybe the provider is closing their practice, but they cover, a nursing home and they haven't let that nursing home know. That's considered abandonment as well. Mistake number 2, violating a non-compete clause. So a non-competition clause will prohibit this provider who's leaving their practice from competing with either an existing practice or a purchaser of a practice for a specific time, whatever the time is. Sometimes it's a year, and in a specific area. These non-compete clauses say you can't set up practice for 1 year in a 5-mile radius around this other practice. So sometimes providers overlook these clauses when they leave a job or other practices and find themselves with lawsuits because they've forgotten about these non-compete clauses because they've opened up a practice in direct competition with somebody that they shouldn't be. So those are 2 mistakes that are made when somebody closes a practice. And that is it. Thank you.